All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our consolidated appeals in CV14-0527 and CV14-0162, Shoemake versus Estancia de Prescott et al. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the clients that you represent. Pursuant to our order sent out last week, each side will have a total of 30 minutes for argument. And Mr. Egbert, as appellant's counsel, you're responsible for watching the clock and reserving any time for a rebuttal that you might desire. We have read the briefs and we've conferenced the case prior to argument. So with those preliminaries, Mr. Egbert, you may proceed.
Good morning, Your Honors. May it please the Court, my name is John Egbert. I represent the plaintiffs' appellants in these consolidated appeals. I'll just march through, beginning with the Yavapai appeal, and until you have questions that you'd like me to focus on in particular. But let me start with the conversion claim that was granted. The trial court granted summary judgment with respect to conversion. And the reason the court did that was, it said, quote, "The court holds as a matter of law that the alleged loss of intangible equity in real estate cannot be recovered through a claim of conversion." Our position...
I think we're going to interrupt you pretty quickly on this one. We'll affirm if the court was correct for any reason. So let's go back and look at what it is your clients alleged as the act of conversion. What was that?
Well, there were several stages of conversion. So when originally Mr. Shoemake takes this real property, transfers it to his own name, and then enters into this transaction by which the equity is stripped.
Well, and wasn't that the act of conversion? And at that point, because of his conversion, your clients had no ownership interest in the properties. So what happened with the disbursement from escrow, they had no interest in that point. What's wrong with that?
No, Your Honor, our position is that you'll recall that he transferred it temporarily to himself and then transferred it back. So,
but after close of escrow?
No.
That he transferred it back? No,
it's my understanding that that happened, but I'm not sure that the timing really should matter, because the reality is that was a theft. It was my client's property the whole time.
Undoubtedly as to Shoemake, yeah. But what I'm trying to get at is, if the act of conversion was him transferring the property into his name, at that point your clients were divested of ownership interest. And so if there were proceeds at the close of escrow that went to other than your clients, well, they'd already been divested of any interest. So how could they have an interest in the disbursements?
Well, before I get to that question, let me just make sure that we all understand that my client's claim against EDP for conversion was not only conversion directly, but also a conspiracy with Shoemake and a aided and abetting of conversion with Shoemake. So I think even if that's all that there was, that those claims are still viable under that scenario if we assume that they had no property interests after that transfer. So even if there was an aiding and abetting and a conspiracy with respect to that stage, in and of itself, we were entitled to present that case and not have it be dismissed on summary judgment.
You did present the aiding and abetting. I know you've got a jury instruction issue on that you'll probably talk about, but remind me what happened with the conspiracy claim.
The conspiracy claim as to conversion was granted summary judgment. So everything related to conversion was gone as a matter of summary judgment. So that's my first answer. So at the barest minimum, that summary judgment was wrong as to that. But our position is that because my clients still continue to have that interest in that property, and indeed when it was conveyed back, they were given that property back in their name as though nothing had ever happened, but what had really happened was that all the equity was taken.
And let me ask you, just so that I'm clear. So the property is in the plaintiff's LLCs. then Schumach puts it in his name, gets the $3.2 million loan, pays off EDP, and then the property is put back in the plaintiff's LLCs, or are they put back before the money is dispersed?
Your Honor, it's my understanding, and I can't cite to you from the record where, but it is my understanding that happened. The transfer back happened shortly after the transfer to him. So it was, let's get this transferred out, let's enter into this transaction, and then it was my understanding that it was transferred back even before the disbursement of the proceeds.
Okay.
And then the transfers then are the interests of the LLCs are deeds of trust that are recorded?
I'm sorry, Your Honor, say that one more time for me.
The interest that the LLCs have in the lots that were purchased, were those interests recorded by way of a deed of trust?
They paid for those lots.
I understand, but I'm trying to, did they get a deed that was recorded on those lots?
As a result of Schumach's activity? Or when they originally...
At the front end at some time?
Yeah, so they purchased the lots free and clear, it's theirs. There's no lien against those lots. Then Schumach takes them and encumbers them at that point in time.
Okay, so, and I think this is part of what we're trying to understand in terms of the factual development. The purchase free and clear was in their name or in Schumach's name?
In the name of the LLC, so the LLC held those. And so the members of the LLC were the individuals and then Schumach's entity. And
Okay.
Schumach was the manager of each of those LLCs.
Thank you.
Okay.
That clarifies, yes.
Okay.
Yes.
So, Your Honor, to get back to the conversion, whether there's something else in terms of the conversion claim, our position is that those proceeds that were derived from the property continue to belong to my clients. And so when they were later distributed and exercised dominion over by EDP, that also was their receipt and exercise of control over those proceeds could constitute the claim of of conversion as well.
But don't you think we need to know clearly what the timing is? Because I think there is an argument that if at the time of the disbursements they were not record owners, they had been divested by Schumach's conversion. I think that's a little different analysis, perhaps.
Well, it may be, but if, as we allege, EDP is aware of this and conspiring with all of this, and that's part of their whole scheme and artifice, then I don't think that matters. I think that if they know that
Not
that's...
as the conspiracy and aiding and abetting, but the outright conversion, it might matter.
Well, I'm not sure that we're not allowing the technicalities of form to override what really ought to happen here in that.
Well, see, I don't see it as a technicality because the definition of conversion is the exercise of dominion or control over someone else's property. And if at the moment of this distribution of escrow, they have no ownership interest in the property, then how is EDP exercising dominion or control over their property? I mean, that's the theory.
So if two people conspire together.
Conspiracy is different, yeah.
I understand, but let's say that my point is if it's true as we allege that EDP understood all of this from the beginning and they're part of this, if that turns out to be the facts that we're able to prove at trial, and so their partner in crime, so to speak, does the first step and on the record falsely indicates that now this is my property, I'm going to go get a loan against it, and then they take those proceeds that are derived from that. It seems to me that we're slicing too finely there to the benefit of the wrongdoers, and that can in fact should be a conversion, because if they knew that was the plaintiff's property, those proceeds, if they knew that really was, I'm not talking about an innocent, third party who just gets paid off the debt by Shoemake. But if we, as alleged, then that ought to be, that's something they know that those proceeds belong to somebody else, even though technically it's in the name of Shoemake's entity or some other entity. That shouldn't matter, I don't think, I would submit. And that in essence is our position. If you say that we're wrong on that, then we have,
Yes,
then we
all right
lose.
positions.
So that's the essence of it with respect to conversion for our position. With respect to fraudulent transfer, we think this squarely fits it within the definition of 44-1004A1 of actual fraud. All the definitions, if you go through, and we tried to do that in our briefing in terms of a transfer, debtor, creditor, claim, actual intent, all of them fit. And so the only thing that EDP tries to do in its answering brief is to suggest, yes, but if that's the case, we acted in good faith and we took for value. Well, there's two problems with that argument. If that's their only argument, then I think they lose because, number one, that's an affirmative defense. That's not part of our allegation that we have to prove that they weren't acting in good faith or that they didn't take for value. That's an affirmative defense, and they didn't plead it in the trial court, and indeed, they did not argue that they acted in good faith in the trial court. So our position is that it's waived. But even if it isn't waived, good faith is quintessentially an issue of fact. And we think we've got more than enough facts in there to raise a genuine issue of material facts. So this should not have been granted on summary judgment, even if they're allowed to raise it at this, that affirmative defense at this stage.
And so is that what you're resting on, is the a person who took in good faith prong? You're not challenging on the record that there was reasonably equivalent value, are you?
No, we're not. I mean, I think there was a debt there that got paid off.
Okay.
The third item we would address is the jury instruction with respect to aiding and abetting. Our position, Your Honors, is that this instruction is incorrect. There is no requirement in the restatement section 876B, which is what Wells Fargo cited in the other cases and that we have in our papers. There is no requirement that there be a shared intent by the aider and abetter.
And if we look at the jury instruction, it
Yes.
says knowledge of Larry Schumacher's purpose is not sufficient for aiding and abetting. EDP must also have shared that purpose or intended to commit, encourage, or facilitate the commission. So it seems like the jury could, it was an either or. And if they, I mean, not an or, it's not an and. So it's not like they had to find both the shared purpose and intended to commit, encourage, or facilitate. They could find either one. And so the fact that they came back with a verdict in favor of EDP at least says to me that they found neither one. And so really that instruction, assuming it's error, is harmless, isn't it?
Well, I don't think so, Your Honor, because if you look at the section 876B of the restatement, there's two aspects of what it requires. It says that the aider and abettor knows that the other's conduct constitutes a breach of duty, so that's kind of the state of mind component. And then the second part is, and gives substantial assistance or encouragement. That's action. Here, the judge's jury instruction that was given really gives both state of mind components. The either or that you're referring to is either shared the intent, had that in his mind, or intended to commit, encourage, or facilitate the commission. So we think that there's no salvaging this erroneous jury instruction. There's no reason why the judge should have not given the Raji instruction, which doesn't bring in this confusion. And our position is that it continues, even granting the or provision, that this jury instruction is confusing to the jury and misled the jury, and we're entitled to an appropriate jury instruction, and it is prejudicial to us. The only argument that the EDP makes with respect to reversible error is that, in its answering brief, is that there's no predicate tort by Shoemake, because Shoemake, as a member of an LLC, cannot does not have fiduciary duties to the other members of the LLC or to the LLC itself. But they're wrong on that score, because Shoemake was not just a member, he was also the manager. And managers do have fiduciary duties. And indeed, he admitted himself that he had those duties and that he breached them. So there is a predicate tort. So their argument in the answering brief is essentially, there's no predicate tort, therefore there can't be aiding and abetting, so there's no prejudice. Well, there was a predicate tort. There is prejudice because the jury instruction was wrong on multiple levels and was confusing, and it should be reversed and allow us to have a fair opportunity to have the jury properly instructed. Now, finally, with respect to our last argument in the Yavapai, and that relates to the motion to amend. The trial court kept talking about delay causing prejudice. This is definitely a case where there should have been an amendment allowed. At multiple levels, this is a mess. With two cases going on, one in Maricopa County, one in Yavapai County, there's efforts to amend the complaint several times in Yavapai. There's efforts to consolidate, and there's extreme prejudice and lack of judicial efficiency and everything else. The trial did not even happen for almost 4 years after we filed our original motion to amend.
I understand why you would tell us that, but really we have to take a snapshot at what the trial judge had before him at the time he ruled on the motion to amend. He didn't know at that point it was going to be 4 more years. And also, with an abuse of discretion standard, this strikes me as a bit of a hard sell. I might have made a different ruling, probably would have, but that's not the standard. So I'm struggling a bit with this argument.
Well, I think when you view it, Judge Downey, in the context of the Supreme Court's repeated instruction to everyone that, look, this should be liberally granted, there is discretion, no question. But in this context, I mean, even if this was done just a few months after EDP had named some additional parties as non-parties at fault. And as a result of that, the judge had already altered the scheduling order, recognizing that would require some additional time. So the judge has already done that. And then when we moved to amend to bring those very same additional defendants in, judge says, well, no, that's going to take too long. That's prejudicial. I mean, to me, that at least that aspect of it is very hard to justify as not an abuse of discretion.
So if we agree with you, what's the impact on the Maricopa case at this point in time?
Well, that's an interesting question, and I think I'll tell you what I would like to see happen here is that not only do we reverse the summary judgment and the trial, the judgment of the Yavapai, but as a result, our position is that Maricopa also has to be reversed because that was all built on collateral estoppel. And so now we've got 2 live cases there. Are we just going to go back and repeat this scenario of having, this schizophrenic effort to get this done? I don't think so. I think what we ought to do is remand to our preference would be to the Maricopa court, because that's the only place where all the plaintiffs have been allowed to assert their claim. The Balboa defendants tried but were unsuccessful in getting into the Yavapai court. So reverse everything, send it back to Maricopa in a consolidated form, and let's do this right this time.
What if the Maricopa case remained viable through a remand, hypothetically speaking? Are your clients still prejudiced because of the denial of the motion to amend in Yavapai? If they're allowed to proceed in Maricopa County?
I don't think so, Your Honor. I think if that scenario occurs, again, when I was briefing this, we weren't consolidated even there on appeal, so didn't know what was going to happen when and where. So to answer your question, I don't think so. I think if it's all reversed and we're going back, then I don't.
Maricopa. If it was
Yes.
reversed as to Maricopa, and if hypothetically speaking, the court determined claims preclusion wasn't valid and that you should be allowed to proceed in Maricopa, then basically your motion to amend argument as to Yavapai is moot.
I believe so. So then that leaves me then to just briefly address the claim preclusion issues. Our first position is, to the extent the underlying judgment is reversed in Yavapai, to that same extent it must be reversed in Maricopa. And I think the law is clear on that. We cited the restatement, marched through that. This appeal, the Maricopa appeal, is still going, so it's live, and it's not like it's a final ruling that can't be addressed. So I think that's our first position. But our second position is with respect to the entirety. Even if Yavapai isn't reversed at all in any aspect, the whole concept of claim splitting and issue preclusion is built, according to the restatement, is built into the law as a protection for the defense. So to prevent the harassment of multiple litigations. But if, as the cases which we've cited in our papers and the illustrations, examples given in the restatement demonstrate, if it's the defense themselves that hinder the amendment or the consolidation to allow all these claims to be brought in one place, then they have, in essence, acquiesced. So our position would then be, under that line of cases, that they've acquiesced to this. And so there is no claim preclusion at all. But our final position would be, certainly, under Arizona's version of claim preclusion that's based on the same evidence test, at least with respect to the Balboa plaintiffs, who were never part of Yavapai, tried to but were refused, at least with respect to the additional defendants that we weren't allowed to add into the Yavapai, and therefore those claims were never pursued and litigated, and at least to the additional causes of action against EDP that we tried to bring into Yavapai and were not litigated in that case, there should be no claim preclusion. I'd like to reserve, if I may, the remainder of my time for rebuttal. Thank you.
May it please the court. My name is Elizabeth McFarland, and today I am representing the appellees Estancia de Prescott LLC, Mr. and Mrs. Hutter, and Mr. and Mrs. Howard. With us in court today are Mr. and Mrs. Hutter and Mr. and Mrs. Howard. I want to first try and clear up some of the misstatement of facts that was just explained to the court. First of all, Mr. Shoemake personally purchased all the lots that are at issue here. And not all the lots at issue.
As opposed to through his LLC?
Yes, Your Honor. He personally purchased the lots at issue here. He then located investors. He then created the LLCs. The LLC was named for Shoemake, the investor, and the lot number that was then transferred into the LLC. And in fact, not all of the lots were free and clear. Some of those lots that were transferred into the LLCs were subject to the Compass Bank kind of blanket deed of trust that the developers had on all the lots. And some of the lots, 15 of the lots, were subject to the Estancia de Prescott carryback notes for the Shoemake purchases, because 15 of the purchases were not outright. 15 of the purchases were $5,000 down and the remainder on carryback notes. So I wanted to give the court the exact reference sites to the records so you can see that for yourself. The first is on the 15 carryback notes. There's an example in the Yavapai appeal in our appendix to the appellee's answering brief, and that's at APP 1. So that's a sample note that shows that Larry Shoemake personally borrowed the money from Estancia to purchase one of those 15 lots.
Let's go back then. So he bought then the 18 lots in his name,
Yes,
found investors, created the LLCs, and transferred the interest of a lot to a specific person, LLC.
yes, Your Honor.
Was that then recorded?
Yes. And that, I don't have that in my appendix. It's probably somewhere in the record of this case, but I did not pull those actual deeds out and put them in my appendix. I apologize for that.
Okay, and then, in terms of the timing, when did that occur as a, in a relationship to the carryback loans?
Okay, so the carryback loans happened first, and that's there's 18 that were purchased free and clear, and 15 that were purchased with carryback loans. So there's a total of 33 lots. Somehow in translation, a few of those lots got lost because when the 2006 loan agreement, the $3.2 million loan agreement is done, it only includes 31 LLCs. So somewhere along the way, two of those LLCs, either Shoemake didn't transfer two of the lots into an LLC that he purchased, or two of the LLCs weren't involved for some reason. I don't know the exact details of that, but I can tell you there were 18 free and clear lots, 15 that were subject to the carryback. Those are transferred into at least 31 LLCs, and the 31 LLCs are subject to the 2006 deed of trust, which
Now,
is...
when he took out the loan, did he take the, okay, so he puts them in the plaintiff's LLCs.
Mm-hmm.
Then, does he ever transfer them back to his name?
Yes.
Okay. And was that before the $3.2 million loan?
Yes,
Okay.
Your Honor.
And when does he transfer them back to the plaintiff LLCs?
After the $3.2 million transaction closed. And how we know this, and this is the second piece of information I wanted to give you, was that in my Maricopa answering brief, in the appendix there at page 125 is the $3.2 million deed of trust. And when we look at that deed of trust, the only borrower on the deed of trust is Larry Shoemake. None of the LLCs are party to that, and that's because record title was all in Larry Shoemake's name, so he was the only one who had to sign the deed of trust to bind all of the parcels that were subject to the $3.2 million deed of trust.
So the title was transferred back to the LLCs after the escrow disbursements.
Yes, Your Honor.
And does that matter in terms of the conversion claim as we discussed with Mr. Egbert?
Yes, Judge Down, you were absolutely right on the conversion claim, and I wanted to talk about that because in the complaint at page 10, lines 11 to 13, the appellants seek conversion of equity resulting from the imposition of the deed of trust. In summary judgment, also, they considered whether the loss of equity could be converted. Now on appeal for the first time, appellants are claiming conversion of loan proceeds. Appellant's argument is a moving target. They're conflating two terms and hoping no one will notice. And you can see this in the reply on page 3. Appellants are not Humpty Dumpty in Lewis Carroll's Through the Looking Glass. A word does not mean what they choose it to mean. Despite appellant's interchangeable use, equity and proceeds...
Isn't that Alice in Wonderland?
No, sorry, Your Honor.
I had me thinking about Humpty Dumpty and Through the
It
Looking Glass,
is.
too.
It's Humpty Dumpty and Through the Looking Glass. I almost brought the book, but equity and proceeds don't mean the same thing. They just don't. And either way, Estancia was not involved in either the transfer of the lots or in the deed of trust. Again, as I just mentioned, Shoemake is the one who transferred the lots, and Shoemake is the one who signed the deed of trust. They now argue, without the benefit of any supporting legal authority, that Estancia should not have accepted payment on a valid debt, and that acceptance constitutes conversion. This court may, of course, disregard that argument.
But what I think the argument in, at least with respect to the equity, is that for the lots that had been purchased free and clear, okay, and had been recorded in the names of the LLCs, that then to transfer them back into Shoemake's name, borrow against all of them, pay off the 15, takes some value from the paid off lots that he wasn't entitled to. And if EDP knew, then whether conspiracy or aiding and abetting, EDP got something, they got tainted money. They got 30 pieces of silver.
And Your Honor, that's exactly where I was going to go next, because Judge Downey was correct. Conversion is the intentional exercise of dominion or control over chattel or personal property. The moment of quote-unquote conversion in this case would have occurred when Shoemake transferred the lots into his own name. Because, to quote Strawberry Water Company from paragraph 11, quote, ownership is vital for standing in the conversion action period. So by the time Shoemake signed the deed of trust, the lots were already in his own name, and as the owner, he cannot convert his own property. It's a legal impossibility.
So if the standalone conversion claim falls away on that analysis, what about Mr. Egbert's rejoinder that, well, we've still got a conspiracy to assist with Shoemake with the conversion?
But if the conversion is the transfer of lots into his own name, there is zero evidence before this court that Estancia de Prescott did anything to help Shoemake sign those deeds, transferring the lots out of the LLC into his own name. There's just no evidence on this point. This is a case where Shoemake is the malefactor. Their beef is with Shoemake. Estancia is an innocent bystander. They could have Shoemake could have gone and got a loan anywhere to pay off the 15 carryback notes, or he could have not paid off the carryback notes. Estancia de Prescott's principals could have found another source to pay their taxes, and in fact, they found another source that they were then able to pay off through this transaction, but they could have gone to someone else. Shoemake could have gone to someone else. This did not have to happen like it did. All that Estancia did was sell lots to Shoemake, take a carryback note back, and say, you know what, you could refinance this. They didn't tell him how to refinance it. They certainly didn't tell him to transfer lots into his own name. There is no evidence of that anywhere in this record. There is no aiding and abetting or conspiracy to that moment of conversion, which is when he transferred, which is, like I said, can't be conversion because it's real property, but when he transferred the notes, the lots into his own name. I'm going to skip over that. On the fraudulent transfer issue, we are in fact bound by what was before the trial court. And before the trial court, there was no evidence of actual intent before the trial court. And in fact, appellants did not even plead ARS sections 44-1004 or 1005 in their complaint, nor did they raise them in response to summary judgment or the cross motion for summary judgment. On summary judgment, appellants did not explain how the acts of which they complain constitute fraudulent transfer within the statutory framework. Instead, according to Judge Mackey, they, quote, strung a number of definitions to, end quote, from the statutes. And appellants have done the same thing before this court. They just string together a bunch of definitions without explaining how that actually constitutes a fraudulent transfer and what evidence before the trial court they rely on to prove actual intent.
Well, let me see if I can summarize what I understand Mr. Egbert's position to be, which is that it's an affirmative defense under ARS 44-1008. Do you agree with that? That's your client's affirmative defense, that it's not voidable against a person who took in good faith or reasonably equivalent value?
Well, yes and no, Your Honor. That's partly my fault. I responded to their argument out of an abundance of caution. Their argument in their brief for the first time was that affirmative defense constitute, whether or not there was a good faith, constitutes a material and fact in dispute which would preclude the summary judgment. That whole issue did not even come up before the trial court. And as he rightly points out, Estancia didn't have affirmative defense an affirmative defense of good faith. It wasn't raised in the briefing before the trial court. It wasn't argued before the trial court. It wasn't an issue on which summary judgment was decided. It is not a material fact in dispute because it wasn't even an issue. And this is another where they raise an issue without any legal authority. So yes, I did respond to their argument. I kind of got sucked in, but it was out of an abundance of caution. It's not, it wasn't material to the summary judgment. On the jury instruction, just to kind of clarify a little bit, the aiding and... Sure.
Before you leave fraudulent transfer, what was their argument down below on the fraudulent transfer issue?
It was literally, they were just stringing together the definitions like they did here, creditor, debtor, but they didn't put on any, if you read what they filed, which I did over the last couple of days, they don't discuss actual intent, they don't discuss evidence of actual intent, they don't discuss whether there was equivalent value. None of it's there. They just kind of throw words at the paper and expect the judge to sort it out. And you see that in Judge Mackey's opinion, where he said, well, both sides cited a bunch of cases, but none of them are on point. And then he cites a case that's perfectly on point. And he said, you know, they didn't raise this, they haven't argued it, and it's just not there. On aiding and abetting, the aiding and abetting claim that went to trial was on breach of fiduciary duty, because as Mr. Egbert had explained, the aiding and abetting conversion went away with the summary judgment motion. On the aiding and abetting instruction, the standard for this court is whether the instruction was erroneous and whether there's substantial doubt that the jury got the proper instruction, and if it was prejudicial. And again today, they omitted the Gomez standard, which is a little bit different. They rely on the Wells Fargo and security title, which relies solely on the restatement second of tort section 876 sub B. Gomez relies on the restatement of torts 876A and B. And in subsection A, there's quote unquote pursuant to a common design with him, end of quote. And in section B, it's only quote unquote substantial encouragement.
What if we assume that that shouldn't have been in the jury instruction and that the Raji should have been given? What about Judge Orozco's question to Mr. Egbert about the or? Is that significant? I think Judge Orozco was exactly right. I think that's very significant. I think that the or solves the problem. First of all, appellants ignore the second half of this instruction in their briefs. They don't discuss at all whether or not the or saves this instruction. There's zero analysis of that in their briefs. And the second thing is that they offer no legal authority that the alternate language makes the jury instruction erroneous. So in other words, if they wanted to argue that the or didn't save it, they needed to provide you some legal authority that says, you know what, even when you have something that's a little bit off, if you have an or that's correct, it doesn't save it. And they offered you no legal authority for that proposition.
Since we get to look at a jury instruction de novo, don't we get to make that determination independently?
Well, you look at the jury instruction to see whether or not it's erroneous, whether there's substantial doubt that the jury got the proper instruction, and whether it's prejudicial.
But we have to find prejudice with respect to all of the totality of the instructions, but we still
Correct.
could find that that instruction was wrong, and then provide guidance to trial court so it doesn't happen again.
Right, if you find that it was erroneous and there was prejudice, and that's the other thing I wanted to touch on, is they offer no legal authority for their argument that they were prejudiced. They just said it was wrong, we lost, therefore we're prejudiced, essentially. And they don't even come so far as to coalesce that whole argument together. They offer no legal authority that the manager to a LLC has a fiduciary duty, neither in their reply brief on page 16 nor today. There was no prejudice to the appellants. They do not identify any prejudice in their opening brief. They say inaccurately, quote, the jury had no choice but to find for Estancia, end quote. And that was to your point, Judge Orozco. The jury actually had a choice. The jury could find that estancia in the alternative, based on an intent to commit, encourage, or facilitate an alleged wrong. And, more importantly, the appellants were made whole, more than whole, by the August 2009 agreement, and they have not demonstrated any prejudice. And the last issue in this case is the leave to amend, which you rightly pointed out is a high bar. That's abuse of discretion. There are many types of amendment. The proposed amendment in this case added both claims and parties. They were not merely clarification or amplification of existing facts. Judge Downey is correct that we're limited to what's before the trial court. Moreover, on page 33 of the opening brief, appellants offer no legal authority for the proposition that actual delay after the leave of amend is grounds for a reversal. The trial court ruling was consistent with Owen v. Superior Court, which I cited on page 37, that there is per se prejudice to estancia as defendant when there's inconvenience and delay occasioned by new parties and new issues.
Well, but doesn't, if in fact you had added non-parties at fault so that the parties were going to have to wrestle with that, isn't it then, understanding it's still within the court's discretion, but you're still going to have to wrestle with those issues nonetheless?
Well, Your Honor, you hit the nail on the head. This is within the court's discretion. When the court exercised its discretion and denied leave to amend, they had options. They could do a special action. They could wait until the proceeding was over and appeal, which they've now done. And in fact, they moved to amend a second time 4 years later. Or they could, ignore the rules completely, run down the hill and file something that's what they wanted to file in Maricopa. So they are getting their day in court in Maricopa. They filed exactly what they wanted to file in Maricopa. That was what they had requested to file in Yavapai, not consistent with the rules, but that's what they did.
Well, that gets us to the Maricopa issue, which it seems to me your clients kind of wanted to have it both ways. You wanted to oppose having these things added to Yavapai, leaving them no choice but to file in Maricopa. So I don't know if you're ready to move into Maricopa, but
yes, sir.
Why shouldn't we find that you've waived the protections of claims splitting and claim preclusion?
So, and this is another, as Judge Flores pointed out, both parties took inconsistent positions throughout these proceedings. But when my clients opposed the first motion to amend in Yavapai County, they did not anticipate that someone would flout the rules of civil procedure and go to another forum and bring those same claims. They anticipated that either...
They're free to do that, though.
Yeah, how is that flouting the rules?
It's not flouting.
That word probably struck a nerve, just because how does that flout the rules? And I was puzzled by the claim they should have appealed. That's not an appealable order. As I recall, they brought a special action, maybe, I don't know which
It was the second one.
ruling, the second one, but they couldn't appeal that. That's not a final
Well, they
order.
could, and they are now. I mean, yes, it
but
takes
wait.
time, but yes, they could have appealed, and that would have been. And when I say flouting, what I meant was going back to 1927, Williams versus Williams, where the Supreme Court said that it's against public policy in this state to bring two actions when one is sufficient.
But you wouldn't let them bring the second action. You didn't want them to.
Well, actually, the court, actually, no, Your Honor. Let me step back. First of all,
You objected to their...
yes,
so if you
but we
objected, you
did
didn't want
not
them to
draft
bring
their
it.
complaint. We did not draft their complaint. We did draft the, we did not do their initial investigation.
And you
Nothing
didn't-
precluded them.
They did name the non-parties at fault.
But the non-parties at fault came from two places. One was the closing statement, and the other was depositions when they found out who the lawyers were. And so they could have done their proper investigation before filing suit and looked at the closing statement. They could have done their proper investigation before filing the lawsuit and looked at the deed of, not the deed of trust, but the loan agreement. The loan agreement listed, and I have that note right here, 25 LLCs. The fact that we only have 14 in Yavapai County, they made that choice. We didn't make that choice for them. We didn't sue for them. They made that choice. And they made the choice to bring the claims that they bring and not bring the other claims that they brought. So while we opposed it, the trial court's the one who made the decision. The trial court could have exercised his discretion and allowed those claims to be brought.
But if the purpose of preclusive effect and anti-claim splitting jurisprudence is to protect the defendant, then the defendants can waive that protection, which it kind of seems you all chose to do. It's kind of rolling the dice from your end by saying, oh, no, not in Yavapai County, and you oppose that pretty vigorously. So it's kind of opens the door to me to the Maricopa County action going forward.
Well, first of all, I want to say to reach the conclusion that they reach in their briefs, they don't cite to a single Arizona case. They don't cite to any law that's binding on this court. And the court on the case on which they rely most heavily, the California Hunt case, in that case, the situation was different. In that case, one party had filed a suit in one county and another party had filed a suit in the second county. And then the first party tried to amend the claim in the first county to include all the claims that were pending in the second county. That was denied because the defendant, who was the plaintiff in the other one, opposed it. Now, when they later complained about claim preclusion, the court said, oh, claim preclusion doesn't apply here because you opposed it. We have the different situation here. In this case, the appellants filed in Yavapai County. They tried to amend in Yavapai County, and then they filed what they tried to amend in Yavapai County in Maricopa County. There were not two dueling cases, and that case is totally inapposite. So really, that's the nub of the claim splitting. The other thing is that they say that we agreed to it, which is what you're hinting at. And the answer to that is no, we didn't. We raised...
Agreed that you waived the protection of claim splitting.
Acquiesced. That we acquiesced. And we did not acquiesce. In the answer to the Maricopa case, there were all of the affirmative defenses of res judicata, claim preclusion, collateral estoppel, they go on and on. There was the motion to stay, another motion to stay, a motion to abate. I mean, there were objections to claim splitting all the way through the Maricopa case that they ignore. They don't include those in their opening brief, and therefore they're not allowed to raise arguments based on those in their reply or today. While we're on the Maricopa case, I agree with Judge Flores. I don't understand how the Maricopa case got there. It just seems like forum shopping to me. Appellants claim they were forced to file in Maricopa County. They had no other choice because Estancia opposed their motion, which is odd.
Why is that odd? That seems...
Because it's both contrary to the rules of civil procedure that permit a special action or an appeal, and it's contrary to Williams.
And we deny, special action is completely discretionary. We hardly ever accept special action review on an abuse of discretion ruling by a trial court. So I just don't understand the harping on them doing something wrong. They filed in Maricopa because you adamantly opposed them bringing the claims in Yavapai. So I'm puzzled by that claim that they did something that the rules frown on.
And the conclusion for forum shopping and disregard of the rules is especially reinforced because although the Balboa plaintiffs dismissed Yavapai 2 after filing in Maricopa, the 14 appellants did not dismiss Yavapai 1. The situation is even more peculiar when we consider appellants refused the Yavapai trial court's offer to consolidate with Yavapai 1 with Maricopa 1, which would have been...
Not only for trial, they tried to get in, the court said, you opposed them, and the court said no. But then they said, well, let's try it all here. That seems to be, inconsistent in terms of, how matters should be handled.
Well, and again, Your Honor, this is when the parties took very inconsistent positions throughout the proceedings. They rejected Judge Mackey's offer to try all the claims together, but they were perfectly willing to have all the claims tried in Maricopa, and you heard that here again today, that they're perfectly willing to have all the claims tried here in Maricopa. And I want to just follow up on something about that, which is they still can't get what they want. He said that, Mr. Egbert said that all the parties are party to the Maricopa action, and that's just not true. A bunch of the parties have either been dismissed or settled out of court in the Maricopa action, and some of the other parties that would need to be joined, like Compass Bank and First American Title, are not parties to that action. So, and as Judge Mackey explained in his opinion, we can't go back in time. We can't undo the deed of trust. We can't undo the sale of lots from Estancia to Shoemake. It's just, we can't put the appellants will never get back to where they don't own lots. It's just a legal impossibility to get there. We can't do restitution because all the parties aren't involved. It's just, and I don't know what more they want, because the 2009 settlement agreement made them more than whole. Prior, at the beginning, they owned 50% of an LLC that owned a lot, many of which were subject to both the Compass deed of trust and the Estancia carryback deed of trust.
But doesn't all of that go to whether they can prove damages if allowed to go forward? It doesn't really address the threshold issue of whether their claims should be allowed to proceed in Maricopa County. I mean, it might be subject to further motion practice if one of the elements is damages and you say as a matter of law they have none, but how does that affect the issues that we have to decide? It's interesting, but...
Well, if we look at the claim preclusion issue, Judge Flores expressly held that we're dealing with entirely the same facts. It's the same $3.2 million deed of trust, and claim preclusion bars a party from raising, in a separate proceeding, raising issues that could have been brought in an earlier case. In this case, the Yavapai 1 judgment is conclusive to every point decided and every point that could have been decided with regard to the $3.2 million deed of trust. The focus of the same evidence test is not whether all the facts are the same, but rather whether the critical facts under Phoenix newspaper or the essential facts under Bill versus Gossett must be proven. If so, then the claims will be considered identical or so closely related as to be identical for purposes of the claim. Here, the same essential facts underlie all the claims, the $3.2 million deed of trust. Appellants describe theoretical difference in evidence, but they do not point to any document or testimony that is critical and different. Moreover, they do not rebut the trial court finding that the exact same exhibits and arguments are involved. Moreover, it is disingenuous for the appellants to suggest they need specific information regarding the Balboa plaintiffs in their reply at 11, because they stated in their opening argument in Yavapai 1 that they, or the closing argument, sorry, in Yavapai 1, that they only need the testimony of Darcy Howard. They don't need the testimony of a single investor. And that was in our brief at page 19. That's
an instance of both parties taking inconsistent positions, because when you were opposing their motion, you said allowing consolidation of the Balboa LLCs as plaintiffs will create the need for factual discovery that would not have been necessitated or expected. And so you're both playing both sides of that issue, don't you think?
Well, but we're now at the point, Your Honor, of talking about claim preclusion. And claim preclusion focuses on whether or not the same evidence is, and it's out of their own mouth at closing argument that they said, we don't even need to put on any information from any investigators. All we had to do in this trial was put on Darcy Howard. And when you read, as Judge Flores did, all of their opening argument and closing statement, they consistently say this is all one scheme, all one transaction, all one pot. And throughout even Yavapai County, they constantly referred to 18 plaintiffs. It is all the same evidence, and we would request that Your Honor affirm both trial court rulings.
Thank you.
Thank you.
Rebuttal, Mr. Egbert?
Your Honor, Your Honors, with respect to the lots, when I said earlier about the lots were all paid off, I was talking about my client's lots, those 18, not the 15 that only Mr. Shoemake bought on the carryback basis. We talk about that in our briefs, the carryback, and so it's not, I just don't want there to be any confusion there about she's lumping in all of the lots, whether they had anything to do with the plaintiff LLCs or not. The plaintiff LLCs are in a different category than the 15 that had the carryback loan situation. Now, with respect to the conversion claim, I want to address a couple things that were raised. They suggest that the equity does not mean the same thing as proceeds. Well, it's kind of like the groundwater in the Strawberry case. The groundwater, when it's before it's pumped and put into the pipes, then it becomes chattel, and therefore it can be subject to conversion. Equity in real estate is just the name of before it gets taken out of the property. And
Follows ownership. I mean, there's no dispute that if your clients had signed a quitclaim deed before the disbursement of the proceeds, they would have absolutely no claim for a conversion. And so this, in effect, they were divested not through their own actions of ownership, but isn't it the same legal analysis?
Again, Your Honor, I don't think so. I think our focus is on the proceeds that were derived from that improper action, and those proceeds, by all accounts, belong to my clients. Those proceeds, under the law, were, stolen from them by Mr. Shoemake. And to the extent EDP knew that, then they knew that they were taking control over our property in the form of those proceeds. One other quick item with respect to the conversion. Counsel makes arguments about, my clients were innocent bystanders, those are great arguments, and they'll have their opportunity to make those arguments, but those are fact-intensive arguments. And the judge here did not rule as a matter of law that there were no fact issues on those issues. That's not something this court can now do and say, okay, well, gee, even if there was a conversion, you guys were, you didn't know anything about it. Those are fact issues which cannot be decided by summary judgment. And here, our claim of conversion went away on summary judgment. With respect to the fraudulent transfer, I'm not sure I understand the argument. They admit that it is an affirmative defense. They admit that it wasn't raised in the trial court. And they complain that all we did was we didn't cite any cases. It's a statutory claim.
As I understood at least part of Ms. McFarland's argument, it was that in the trial court you did not raise the quote-unquote factual issue of whether your clients acted in good faith, and therefore your argument today that that's a factual question should be deemed waived.
Your Honor, we did not, to the extent she's saying we did not raise their affirmative defense of good faith, she's right. But we're not supposed to. That's not how affirmative defenses work. Defenses are raised by the defendants. And so we didn't raise it, and they didn't either, is the more important point. And because they didn't, then they shouldn't be arguing it today. And even if they are, that's going to be an issue of fact that cannot be decided on summary judgment. We strung together the definitions because that's how you analyze a statutory claim. You look at all the terms used in the statutory cause of action, and they're all defined in the statute. So we marched through that and demonstrated that there was a fraudulent transfer, and their only option, their only way to get out from under that in terms of whether the summary judgment was improper was to say, hey, we got an affirmative defense, which they didn't raise by their own admission. And even if they had raised it, the judge could not resolve that affirmative defense at the summary judgment level. With respect to the jury instruction, I don't want to beat a dead horse, but I do want to point out this is significant. They rely on the restatement section 876A, not B. A is not aiding and abetting. A is a different issue altogether. It doesn't help their argument. With respect to somehow the summary judgments should be affirmed because we were made whole, allegedly by a settlement with some other party, again, that wasn't litigated below. That's not the summary judgment issue before this court or the trial court for that matter. That has nothing to do with the issue here. And I think that the court gets, with respect to claim preclusion, that this whole concept is something that benefits defendants. So even if it were true that my clients took inconsistent positions, we're not the ones that are benefited from the rule against claim splitting and claim preclusion. They're the ones that are, and to the extent they reject the benefits by not allowing the amendments or the consolidation, then that's an acquiescence or a waiver of that doctrine.
And does your client's decision not to permit the cases to be tried together in Yavapai County have any bearing on those issues?
No, it doesn't, Your Honor, because again, we're not the one. Context is important here on that issue, because at the point in time where now they're saying, oh, come on back, everybody come back to Yavapai now that you filed this Maricopa case. And by the way, importantly, we'd already gotten a ruling in Maricopa that was the direct opposite on the conversion claim. And so now they want us to, in essence, give up on the conversion claim, go back and have it tried in front of a judge who's now telling us erroneously that we can't have a conversion claim. But leaving that aside, the fact that we said no to that in that context, I think was appropriate. But even if it was inconsistent, it's not held against us, because again, the doctrine of claim splitting and claim preclusion is a protection for defendants. We haven't acted inconsistently by not accepting something that's for their protection. I also want to point out that the New Mexico case that we cite for the issue of acquiescence, that was a situation where there had been affirmative defense raised in the answer about res judicata and those types of things, and the court said, you got to do more than that. You just can't raise it and then sit on it and then litigate the two tracks and then someday later raise it. You have to assert it affirmatively, and otherwise you're going to be deemed to have acquiesced. Unless there's other questions, we would ask the court to overturn both judgments below.
Thank you.
Thank you.
Both for your arguments. The issues were well briefed and well argued, and we appreciate that. We will take these matters under advisement and issue a ruling in due course. And at this time, the court stands adjourned. Thank you.